All right, we'll take the final case on the docket, which is Thorn versus the City of Ormond Beach. I presume everybody's ready.
Yes, Your Honor. Good morning. May it please the court, my name is Felicia Steele with the Steele Law Firm out of Tallahassee, Florida. I have with me Daryl Parks from Parks & Crump Law Firm, also out of Tallahassee, Florida. And we represent the appellant, Miss Betty Thorn, who's the guardian of Deborah Hosendorf. This appeal arises out of a tragic automobile accident that occurred in July of 2004 when Deborah Hosendorf was injured in an automobile accident where she was struck by a car that was driven by Thomas Larson. The facts in the record establish that at the time of the accident, Mr. Larson was employed by the City of Ormond Beach Police Department as a patrol officer. That when the accident occurred, he was in his full uniform, had his badge, his gun, and all the accoutrements necessary.
Yeah, but where was he going?
He was on his way to an extra duty assignment that had been obtained from an assignment from the City of Ormond Beach. The extra duty assignments.
How is that different from going to and from work?
Because the extra duty assignments, Your Honor, are assignments that are only given through a contract between a private employer and the city.
So if he were going to the police station, your client would be out of luck?
That is correct, Your Honor.
So, but because he's going to this private function, for some reason, from his home, to driving his own car.
Driving his own car,
that makes a difference.
Yes, Your Honor, it does make a difference. The difference is because he is, in fact, performing his duties under the contract that the City of Ormond Beach has with this private employer. If I may, what happens is there's a contract, and in order for the contract was for services to provide police security at this private entity, as the court has indicated. In order for the city to perform its obligations, it had to send one of its police officers. That assignment was made to Mr. Larson's. Mr. Larson's was required to report at a particular location to perform the duty and to have basically the things necessary in order to carry out the duty.
Was he on the clock at the time of the accident, or was this a deal, for example, where they wanted him on duty at 8 in the evening until midnight or whatever, and at 7:30 on his way to work the accident happens?
Your Honor, based upon the facts that are in the record at this time, that is the situation. He was to be there at 10:30. It was 10:22. He was appearing. He was on his way, if you will, when the accident occurred. The reason that this case, this set of facts is different from that is normally considered under the workman's comp rule of going and coming is that, and that is one of the issues that we have before the court that are on appeal is the fourth issue, is that there was a mission that Mr. Larson's was performing at the behest of the city. He was carrying out the city's duties under the contract.
Well, but how was that mission any different than if he had been scheduled to just do a regular shift and he had to report to the police department to start work at the same time? Because,
Your Honor, when he received the assignment, from the time, and we have cases that we cited, and I also have the cases here with me, that because he had a location that he had to report to, an assignment he'd been given by his employer, from the moment he left his home en route, he was in the process of doing the things necessary in order to fulfill that mission.
Well, wait. Now, you're familiar with the Garcia case?
Yes, Your Honor.
Fourth District case?
Yes, Your Honor.
That case says that, among other things, that the reason they were ruling in favor of the police department there is because the officer involved was not doing his primary responsibility as a police officer when he was engaged in driving to the police station. That is, he was not engaged in the prevention or detection of crime or the enforcement of penal, criminal, traffic, or highway laws of the state. He wasn't doing either one of those. He was just going to work. I'm having a really hard time, Ms. Steele, just to be straight up with you, having a really hard time seeing how that's any different in this case.
Yes, Your Honor. If the analysis is limited to the workman's comp going and coming rule, but as the court knows, we filed a brief where we've raised 4 issues, and I would like to, with the court's permission, address those issues in order to make sure that...
Read it.
Okay. First of all, the first issue, Your Honor, is that we believe that the court applied the wrong law in terms of evaluating the facts in this case. This is a tort, obviously, as a case, and we brought a multiple count complaint alleging, among other things, respondent superiority as well as vicarious liability. And under tried and true established common law, when an employee injures a third party in the course and scope of their employment, then in fact the employer is responsible. And the case law, and we cited Sussman, indicates that there's a 3-pronged test that must be included. And it says the 3-pronged test, and I'm certain the court's familiar with it, is that 1, it is a kind of job that is expected to be performed. 2, it occurs within the time period necessary to perform the job. And 3, it furthers the interest of the employer. Your Honor, we believe that the facts and records established all of that. And also what Sussman says, and it is a third DCA case, it says that essentially importing workman's comp law wholesale into a tort action, while workman's comp is instructive, is not definitive. We need to look at all of the facts and make a determination as to whether or not the person was within the course and scope of their employment at the time.
Well, let me ask you, I'm a judge 24 hours a day, and I can perform my duties from home or work, but if I'm driving from my home to the courthouse and I'm involved in an accident, is the state responsible under respondeat superior for my negligence, assuming I'm negligent?
Your Honor, it requires additional analysis. If the court is on its way to the courthouse that you normally work at, then that would be one set of answers. However, if you're going to a location that is not your normal location of doing business, and we cite a number of cases here where when the person is going to another location, not the location where they go in and day out and perform their duty, where they're going to a separate location, at the request of their employer, then yes.
But don't those cases have to do, it's like the plumber leaves the plumbing headquarters and he's going out to your house to, fix your leaky faucet. I mean, that seems to me to be a different story than the plumber leaving his house going down to the plumbing shop or plumbing headquarters.
That's absolutely correct, Your Honor, and we are actually arguing the former, not the latter. We're arguing that what actually happened here is not that it was a normal, customary job. This was a special assignment. This was a contract that was being carried out by the employee of the city on behalf of the city with a third party. The city benefited from that contract. They were paid based upon the evidence that we have in the record, and the city paid the employee. Now, going through that 3-pronged test, 1 was the job to perform similar to the job that was expected. The fact of the matter is there was a contract that Rock and Ranch had with the city to provide police security. Mr. Larson's was on his way in his full dress to provide that security. Anything that he did to further that interest was part and parcel of performing that job, first. Secondly, did the incident occur within the time span of the actual action of the employee? And yes, it did. The accident occurred on his way to work. And thirdly, did it actually do something for the employee's benefit? In other words, was it in the employer's interest that the employee performed this task? And yes, it was. There was a contract that the employer had. But, Your Honor, we believe that even if all of the facts do not address each of the 3 prongs that are laid out in common law as to the issue you must look at in determining whether an employee was within the scope of employment under vicarious liability, that the facts as they are currently in the record, there's an inference that can be made. And under the summary judgment standard, if the inferences can lead to more than one conclusion, summary judgment is not ripe. And therefore, we believe that, again, the third issue that we're raising on appeal, that summary judgment should not have been entered in this instance. And the fourth that Your Honor has addressed is whether or not it is something that's covered under the going and coming rule. Again, we would assert that the exception. The exception is that there is a special mission or an errand that has been taken on by the employee at the employer's request. And we've cited in our brief a number of cases that speak to different incidents in which this did in fact occur.
But usually the special mission is something like, okay, you go from if you're going from your home, instead of coming directly to the plumbing supply store, plumbing headquarters, go over to the plumbing supply store first, pick up 14 wrenches and bring them over. That's a different kind of thing than just simply going to the place of employment, which I think is what we have here.
Well, Your Honor, I have a couple of cases, and both of them are out of the first DCA. We've actually cited them in our brief. The first that I want to speak with the court about is, and forgive me, I'm probably mispronouncing this, it's Schoenfelder versus Wynn and Jorgensen, PA. It involved an attorney who was going to do a brief, an attorney who was going to take the deposition of a party. And he took the file home to study it, and he was going to go take the deposition the next day. He got up approximately, I don't want to misrepresent the case, 7 and 7:15 and began preparing in the morning, preparing for the deposition. And as he was leaving his home to get into his car, he was struck and injured. Now, this is a workman's comp case. And the workman's comp mediator, judge, stated that, in fact, it was not within the course and scope of his employment because he had not arrived at the deposition location. However, the appellate court said that, in fact, everything that he did was furthering the mission of his employer to include, and that, in fact, this is doing just a brief on the case, from the point of preparing for the deposition to getting into his car to driving, that it in fact, all of that was part and parcel of the special duty that he was performing for his employee. And I'm paraphrasing here.
I think the court there determined that it was because that this was a regular part of his employment, that there was no significant break or interruption.
Okay. Yes, Your Honor.
As opposed to going to and from your place of employment, period.
Well, it did not make that narrow determination, Your Honor. I agree.
Well, that's what your brief says. That's why I'm reciting.
Right. However, Your Honor, thank you very much. But however, what the case itself says is, look, in order to take that deposition, all of these actions were taken in order to further the goal of taking the deposition, and so there was no break. And we have this case, Your Honor. We, of course, have the case that Your Honor is referring to when you talk about the plumber. There's, in fact, the Johnson case where the individual was on his way to work. He stopped to pick up gas because that was something he used, and the court found that he was within the course and scope of his employment. But we also have a case involving a number of other individuals that we cited in our brief, Your Honor, that goes beyond just a straight going and coming to and from work. It actually speaks to employees who are, in fact, performing special duties above and beyond what they normally do. And we believe whether the court reviews the facts in the case based upon the vicarious liability, the three-pronged test to determine whether or not the party is operating within the course and scope of their employment, or conversely, to view it from the workman's comp perspective only, that the facts support that. And if the court finds that that the facts don't mirror, because there is no case on point, there's no case that I've been able to find, and we've done a pretty big search, that is quote-unquote, on all fours regarding this particular set of circumstances. Cannot find a case where an employee was fulfilling the contractual obligations for his employer. There's no case like that out there. Could not find a case where, in fact, the employee was actually doing or en route to fulfill that duty when he, again, the contract was employed when the accident occurred. And so we believe that because there is no established jurisprudence to actually on all fours regarding this, and because there is disagreement regarding the facts and inferences to those facts that can be different conclusions to, and not just one, that in fact it was an issue for the jury to decide as opposed to the court. And we've cited a number of different cases that speak to that issue, whether if two people can come up with two different conclusions, then in fact it is not right for summary judgment. And so we're asking, Your Honors, that this case be remanded back to the trial court at the very minimum to ensure that there's a hearing on what we believe to be the correct standard, which is the vicarious liability standard, the three-pronged test. And we ask that the court rule accordingly. And I'd like to reserve the remainder of my time.
Thank you, counsel.
May it please the court, Mike Walker on behalf of the city. I think the fallacy of what the appellant is arguing is on display at page 11 of their brief, where they essentially are arguing that Officer Larson's conduct occurred substantially within the time and space limits authorized or required by the work to be performed, and then go on to say, but for the city's actions in contracting with the Rock and Ranch, Larson would not have been en route to the bar. That pretty much lays out what their argument is. What they're in essence arguing for is a but-for standard of vicarious liability, saying that in essence anything that the employee did leading up to the time and place of employment, but for them being in that particular place or doing that particular act, would somehow impose liability on the employer. The problem with that is when you start to use your imagination and go backwards in time and become more and more attenuated from the time and place of employment, you can argue that virtually everything an employee does all day long in some way relates to their employment. When they get out of bed in the morning, but for their job, they wouldn't necessarily get out of bed. But for their job, they wouldn't necessarily be walking to their vehicle or any number of things. So,
counsel, let me just ask you, would you agree that if, I forget the name of this, the officer, would you agree that if he had gotten up, left his house, driven to the police department, and then gone to the Rock and Ranch, and been in the same place, involved in the same accident, that he would have been in the course and scope of his employment?
I don't know that I can take a position on that, on those exact set of facts. Typically, a police officer begins their shift by going to the station house. And the reason for that is what you see right here, because there has to be a beginning and an end, and the police department has no control over the manner in which the person travels to the station house in the first place. And so, let me answer the question this way. If Officer Larson had arrived at the Rock and Ranch, I believe he would have been within the course and scope of his employment
the moment he arrived.
When he arrived and began his shift.
All right.
The key.
And we know that if he was going from his home to the police station, that he was not in the course and scope of his employment. That
would typically be the case if he was going to the police station to begin his shift, because the key to it is the employment is tied to a time and a place.
Right. It's the going and coming rule.
It's the going and coming rule. I mean, it's really
going and coming from your work.
Right.
But if he leaves the station and goes to the Rock and Ranch, isn't he at that point in time in the course and scope of his employment?
If it could be said that he began his shift began his employment by first going to the station house. For instance, if he was required to go to the station house first and then be dispatched to the Rockin' Ranch for his security detail, I would say it definitely would be arguable that when he got to the station house, he began his shift.
And so when he was on his way to the Rockin' Ranch, he was in the course and scope of his employment.
Because he would have begun his shift by his arrival, and at that point, he would have been under the direction and control of the police department.
But if you went to the police station before arriving at the Rockin' Ranch, either because it was a secretary's birthday and he wanted to wish her a happy birthday, or he forgot his flashlight and he just wanted to get his flashlight,
then that would be a different scenario.
So I guess I'm trying to understand if the argument is that merely showing up at the police station somehow changes the rule, or if the rule is once the employment actually begins and you're doing something for the benefit of the employer.
I think the way you have to analyze it is you have to think in terms of the control issue, because that's really what it boiled down to.
Well, but admittedly, he's a police officer 24 hours a day.
Right.
I mean, if he saw a bank robbery on his way to work and wanted to jump out of the car and go do whatever policemen do to stop bank robbers, and in the process of that he had either been injured or had injured someone else, there'd be a pretty good argument that he was on the clock, so to speak, even though not formally. He was performing his duties as a police officer.
He's enforcing the law, or attempting to at that point. I know that there's a lot of case law. Usually the case law that deals with those kinds of issues deals with the question of whether the business that's employing the officer is a co-employer of the officer and that type of thing. I don't know really what that scenario has to do with a case where we're talking about a prearranged, long-standing assignment where an officer is assigned to a particular location for a fixed period of time. And that is the scenario that we're talking about. And
I think this was a regular assignment.
Absolutely, and he testified to that in no uncertain terms. There was nothing special about this. In other words, there is case law. There's an exception to every rule.
Special errand doesn't necessarily mean that it only happens once.
No.
Special errand is like, you need to go by the plumbing supply store and pick up a wrench before you come and do your plumbing work. And I'm having trouble, frankly, understanding the distinction between, going to the plumbing supply store and picking up a wrench. We know that in those circumstances, if you go someplace other than your place of employment, that you're on a special errand.
It's because
I'm having trouble understanding why this guy's special errand didn't start until he actually arrived at the Rockin' Ranch. It may very well be true that he didn't start his special errand until he got there. But the distinction, frankly, is eluding me, and it may depend on the contract itself.
No, I think the distinction, that what you have to understand is what you're talking about, if it's part of my employment to go someplace and pick something up, or part of my employment to go put gasoline in the lawnmower, then that's not a special errand. Within the case law that talks about that exception to the rule, that's not a special errand. That is simply part of your employment.
Going to pick up the wrench is a special errand.
Right, and see what happens is you can go pick up the wrench on your way to the office. You're going to the store and they say, okay, well you leave your house, but you're under the direction and control of the employer, because part of your job is to go to this place, pick something up and bring it back. It's like a delivery driver.
Right, I understand that. So what's different if I send you for a wrench or I send you to be the security detail at Rockin' Ranch? What's the difference? Because
the security detail was the time and place of the employment. There was no intervening assignment. There was no intervening duty. There was nothing. Look at it this way. Officer Larson left from his home wearing a partial uniform. He wasn't wearing his utility belt, but he left from his home wearing a partial uniform and was going to the Rockin' Ranch. That's the facts. he could just as easily have been leaving from the movie theater and have his uniform and his gun in the car and dress when he got to the rocking ranch. In other words, the employer is not exercising any control over what route he takes, what vehicle he takes, what he's doing, whether he's wearing a uniform or not.
Well, that would be true with the wrench guy as well.
No, it wouldn't be true, because in your example, the person is being directed by his employer to go to the wrench place and pick up a wrench on his way to fulfill his duties at his place of employment. There's an intervening responsibility.
What's important isn't that he was on the way to work. What was important was that he was given an errand to go do something else.
It wasn't.
He would be it would be the same thing if he was on his way home and the employer sent him to pick up the wrench on his way home. It's not that he was on the way to work. It was that he was given a special errand.
This was his work. That's the distinction. In other words, you have to make this distinction. There's an exception. I don't know if you'd call it an exception, but there's a principle called special errand or mission. Now, this was not argued below, and I don't believe they've raised this in their briefs. I don't think they're arguing for an exception or have argued for an exception in the briefs and said this falls within the exception. But I'll go into it a little bit anyway. A special errand or mission is something which is sudden or urgent or unusual, where an employee is being called into action other than their normal time and place of employment. In other words, let's say, for example, Officer Larson had been at home and he gets a call on his radio that says, hey, there's a riot at the Rockin' Ranch. Grab your gun and your badge and get on down there. Now, that's a special errand. That's a special mission. And on the way to the special errand or mission, there's case law to the effect that he may be within the course and scope of his employment.
So if he was home and they called him and said, go to the Rockin' Ranch and investigate X, then there'd be liability.
There may be, yeah. I'm not saying there would be, but that would be a different scenario than a prearranged,
but because it was
long-standing
prearranged
assignment
for him to go to the Rockin' Ranch, then there's no liability.
Exactly.
Does that make a lot of sense to you?
Absolutely it
Why?
does. Because if you read the cases dealing with special errands and missions, it's the urgency and the unusualness of calling the employee into action that takes them from being a private citizen on their way to work and turns them into an employee. Because that's, that I can see the logic of saying that if I call somebody up and say, hey, you need to come on down on a Saturday morning.
Going back to our plumber, if he had to go by the plumbing supply store every morning, there's no liability. But if his employer just called him and said, hey, bud, this morning I really need a special wrench, go by there today. That's what makes it a special errand. Otherwise, there'd be no liability in one case and liability in the other.
No, that's not true.
That doesn't make any sense to me.
That's not how the law works. That's not the law.
But you said it had to be urgent and unusual. If he goes by every day, there's no liability. If it's urgent and unusual, there is liability.
Let me put it this way. If Officer Larson let's say he was using a city-owned vehicle to go to the Rockin' Ranch, and his supervisor called him up beforehand and said, are you going to the Rockin' Ranch to be there for your shift? And he said, yeah. And he said, I want you to take that vehicle to the gas station and fill it up on your way there. Now, Officer Larson is not merely going to his place of employment. He is now on a specific, defined task, which he has been given by his employer at that point. He's not on his own time anymore. He's been told to go do something. And when he's going to do it, then when he's on his way to the gas station, he's within the course and scope of his employment at that point.
Do we know how the officer was compensated?
Yes.
How was he compensated?
He was paid through the department for his overtime, which was paid by the business owner.
When was it calculated from?
Yeah.
I'm sorry?
When was overtime calculated?
10:30, when he arrived at his...
At the Rockin'
At the Rockin' Ranch, when his shift began. In other words, he was supposed to be there from 10:30 to 2 o'clock or whenever the the bar let out.
So he was not paid travel time?
No. He was being paid for a specific shift. And so I think that the problem with your example with the plumber is that it's not, the getting of the wrench is not a special errand or mission. It's simply part of his employment. It's like going to put gas in the lawnmower if your job is to mow the lawn. It's part of what you have to do. You're not merely going to the place of employment.
If the plumber's employer had called him up and said, instead of coming to work this morning, go to Judge Orfinger's house and fix his plumbing.
He would be, that would be a situation where he would definitely be within the course and scope of his employment. Just like a plumber who, why would it make any difference whether he had arrived at the plumbing place and then been dispatched, or whether he was dispatched from his home? It wouldn't be any different in this situation if someone had called up Officer Larson and said, like I said before, there's a crime in progress at the Rock and Ranch, get down there. If they've dispatched him, tasked him to go to the Rock and Ranch, then it's arguable that the time that he takes to get there, he's within the course and scope of his employment. But you have to draw a line.
Haven't they tasked him to go do security at the Rock and Ranch?
Not in that sense. It was a prearranged, long-standing security detail. In other words, it was just part of his regular employment. It was a shift that he signed up for, volunteered for, and was assigned to. Long before the accident ever happened. In fact, I think he testified in his deposition that this particular shift, this particular assignment had been in place for several years. It was a regular thing. So it's not a sudden, unusual, special errand or mission. It's just part of his job, and that's where the job is. That's where it starts and that's where it ends, at the Rock and Ranch. So, you have to think about this in terms of why we draw. I mean, it's a bright line rule, and anytime you draw a bright line rule, you can always come up with examples and on the fringes to question, well, maybe we should draw the line a little bit further this way or a little bit further that way. But when you start to engage in that in this context, like I said before, the more attenuated you become from the time and place of employment, the less and less control the employer has over what the employee is doing. He was in his own vehicle. The city doesn't have any control over whether his vehicle is maintained. They don't have any control over the route that he uses. They don't have any control where he was coming from or what time he left or anything. He was simply a private citizen on his way to work. And if you start drawing the line further and further attenuated from there, think about the technical, logistical problem that you create for the employer, who now has to question, when does my employee leave for work? How are they going to get there? What car are they going to drive? You have to draw a line somewhere and say, look, we're going to cut liability off if a job involves a particular place and a particular time, and that's your normal schedule, your normal place of employment. You don't start your employment, you're not within the course and scope until you get there. And that's the bright line rule, and it has been for 75 years, and I don't see any reason to start shifting it around now. This is why Officer Larson buys automobile insurance. It's his car, and he's on his time when he's heading to the Rock and Ranch. So, I don't think, like I said before, they have not argued in the briefs and did not argue below for an exception to the going and coming rule. The argument being made by the appellant is you have to apply the common law test, the common law prong test, to determine whether the employment itself, the job itself is within the course and scope of employment. The problem is that test doesn't begin until you get to the job. You have to start the job in order for those issues and those questions to even be addressed. So I think it's a bright line case. There usually aren't that many in the law, but This is one of them where he was assigned to a particular time in a particular place. It was a long-standing assignment, and he didn't get there yet. So I don't see how the city can be liable for what he does on the way to the job. So I don't think I have anything else. Can I reserve my last minute?
No.
You're done.
Happily.
Okay. Thank you.
May it please the court, first as to whether or not the exception was included in the brief, it is under issue number 4 in the appellant's brief.
Ms. Steele, suppose this person was not employed by the city at all, but was employed by the Rockin' Ranch as a security guard, private security guard. And he had the same, the rest of the facts are the same. He has the accident on the way there. Would Rockin' Ranch be liable for that?
No, Your Honor, because if Your Honor applies the going and coming rule, the workman's comp rule, no, he would not. Because he would be going directly to his employer's place of business.
The only difference here is that he happened to be employed by the city.
He was employed by the city. The city sent him on a duty.
Would it make any difference then under that same scenario that instead of employing, let's leave the city out, Rockin' Ranch has an arrangement with Brinks Security to supply on request security guards. So, on a particular night or, a week in advance, they call up Brinks and they say, we'd like a guy for Saturday night, 10 o'clock. And Brinks looks at the list and says, okay, we're going to send Joe. So Joe's driving over to the Rockin' Ranch from either wherever he lives or Brinks headquarters or something. And on the way, he's involved in an accident. Forget the workers' comp and his issue with Brinks. Is the Rockin' Ranch responsible as, because he was on their way to work to do a job for them? Under your theory, would the Rockin' Ranch be responsible for that accident?
No, Your Honor, because the employee is being sent by Brinks. It was Brinks who made the decision that Brinks chose the employee to go to Rockin' Ranch. And it wasn't something that Rockin' Ranch decided which employee would go. Again, the argument is under respondent superior, under vicarious liability, is that the employer has the responsibility of controlling.
Okay, so to flip my example around though, your argument would be that as to the injured third party, Brinks would be responsible to the injured third party for Joe the guard who's driving from his home to the Rockin' Ranch.
That is correct, Your Honor.
Okay. So the fact that we have a city here doesn't really concern you. It's not their status as a municipality, it's their status as his ultimate employer.
That is correct, Your Honor.
Okay.
That is correct. And I did want to, and I know these cases are in our...
Steele, what about the fact that he didn't get paid until he got there?
Your Honor, that is unclear in the record. I understood counsel to say that he's to be on duty at 10:30, but we don't have any record evidence that he did not begin to be paid until 10:30. Nor do we have any record evidence that he didn't get reimbursed for his expenses. I took his deposition. I don't recall it. I reread it. Maybe I overlooked something, but I don't recall any question. I don't think I asked that question directly as to whether or not he didn't get paid for his travel expenses. So I can't respond to that other than to say I don't know where that is in the record that he did not get reimbursement for expenses.
So we don't know whether he was paid from the time he left his house?
We don't know. And in fact, we do not, as we stand here today, have a copy of the contract or that would be able to tell us exactly what was required.
I'm sorry, did you say that we do or don't have?
Do not. We do not have a copy of the contract. And I have 1 second left.
You've exhausted your time. Thank you very much.
Thank you, Ron.
Thank you both.